Judge Barrett, under federal law, is it illegal to intimidate voters at the polls?
I can't answer questions like that.
We're talking about the entire foundation of our democracy here. For centuries, Americans have fought and died to protect the right to vote. And so what matters is not just what you say about its being fundamental, it's what you do. States like South Carolina, Texas, North Carolina, Louisiana, Tennessee have policies that make it harder for people to vote. And it's a real-world thing before the Supreme Court. In fact, back in May, when voters in Wisconsin were standing in line in the middle of a pandemic, in homemade masks, in garbage bags, in the middle of a rainstorm, just to exercise their right to vote, 70 of them got COVID, because we didn't know enough about it back then, because the president hadn't told us what he knew, and we didn't know enough to protect those voters. So it ends up at the Supreme Court. What did Justice Ginsburg do? When the Republican-appointed majority on the court ruled that voters in Wisconsin could not have more time to get their ballots in during the pandemic, she called them out in her dissent, in her blueprint for the future, and she said the majority opinion boggled the mind. So what boggles my mind? Well, 2 weeks ago, the U.S. Supreme Court reinstated the South Carolina requirement that mail-in ballots must have witness signatures. In the middle of a pandemic, you got to go and get a witness. In Texas, Republicans have argued that the pandemic wasn't a good enough reason to let people under age 65 vote by mail, despite the fact that over 42,000 Americans under 65 have died from COVID. And the governor right now is forcing that state to have only one ballot box per county, including in Harris County, where there are 4.7 million people. And for those of you that thought a judge took care of it a few days ago, he did. But then yesterday, 3 Trump-appointed judges came in and reversed that. So we're back to one ballot box for people to drop their ballots off in a county of 4.7 million people. In Tennessee, Republicans have tried to prevent ballot drop boxes. I know we had the Secretary of State as one of our witnesses at a Rules Committee hearing, and they have argued in court that COVID-19 is not a valid excuse to vote by mail. In North Carolina, the Supreme Court struck down a core component of the Voting Rights Act. What happened? Well, states like North Carolina passed laws that were so egregious to make it harder to vote that the Fourth Circuit struck down their law and noted that it targeted African Americans with almost surgical precision. So that is what the stakes are. And that is why not having Justice Ginsburg on the court right now is so frightening to so many Americans out there. And that is why we are asking you these questions about voting. Last week, a contractor from outside of my state of Minnesota started recruiting poll watchers with special forces experience to protect polling locations in my state. This was clear voter intimidation. Similar efforts are going on around the country, solicited by President Trump's false claims of massive voter fraud, something that, by the way, many Republican leaders, including Michael Steele, the former head of the Republican Party, including Tom Ridge, including Governor Kasich, including sitting Senator Romney, have made very clear is not true. So as a result of his claims, people are trying to get poll watchers, special forces people, to go to the polls. Judge Barrett, under federal law, is it illegal to intimidate voters at the polls?
Senator Klobuchar, I can't characterize the facts in a hypothetical situation, and I can't apply the law to a hypothetical set of facts. I can only decide cases as they come to me, litigated by parties on a full record after fully engaging precedent, talking to colleagues, writing an opinion. And so I can't answer questions like that.
Okay, well, I'll make it easier. 18 U.S.C. 594 outlaws anyone who intimidates, threatens, coerces, or attempts to intimidate, threaten, or coerce any other person for the purpose of interfering with the right of such other person to vote. This is a law that has been on the books for decades. Do you think a reasonable person would feel intimidated by the presence of armed civilian groups at the polls?
Senator Klobuchar, that is eliciting, I'm not sure whether to say it's eliciting a legal opinion from me, because the reasonable person standard, as you know, is one common in the law, or just an opinion as a citizen, but it's not something really that's appropriate for me to comment on.
As a college student in the 1950s, I saw what happened to young women who became pregnant at a time when abortion was not legal in this country. I went to Stanford. I saw the trips to Mexico. I saw young women try to hurt themselves, and it was really deeply, deeply concerning. In Planned Parenthood of Southeastern Pennsylvania versus Casey, Justice Scalia, as was said earlier, joined the dissent, which took the position, and I quote, "We believe that Roe was wrongly decided and that it can and should be overruled, consistent with our traditional approach to stare decisis in constitutional cases." Do you agree with Justice Scalia's view that Roe was wrongly decided?
So, Senator, I do want to be forthright and answer every question so far as I can. I think on that question, I'm going to invoke Justice Kagan's description, which I think is perfectly put. When she was in her confirmation hearing, she said that she was not going to grade precedent or give it a thumbs up or a thumbs down. And I think in an area where precedent continues to be pressed and litigated, as is true of Casey, it would be particularly, it would actually be wrong and a violation of the canons for me to do that as a sitting judge. So if I express a view on a precedent one way or another, whether I say I love it or I hate it, it signals to litigants that I might tilt one way or another in a pending case.
So on something that is really a major cause with major effect on over half of the population of this country, who are women, after all, it's distressing not to get a straight answer. So let me try again. Do you agree with Justice Scalia's view that Roe was wrongly decided?
Senator, I completely understand why you are asking the question, but again, I can't pre-commit or say, yes, I'm going in with some agenda, because I'm not. I don't have any agenda. I have no agenda to try to overrule Casey. I have an agenda to stick to the rule of law and decide cases as they come.
Well, as a person, I don't know if you'll answer this one either. Do you agree with Justice Scalia's view that Roe can and should be overturned by the Supreme Court?
Well, I think my answer is the same, because, that's a case that's litigated. It could, its contours could come up again. In fact, do come up. They came up last term before the court. So I think, what the Casey standard is, and it's a contentious issue, which is, I know, one reason why it would be comforting to you to have an answer. But I can't express views on cases or pre-commit to approaching a case any particular way.
Well, that makes it difficult for me, and I think for other women also on this committee, because this is a very important case, and it affects a lot of people, millions and millions of women, and you could be a very important vote. And I had hoped you would say, as a person, you've got a lovely family, you understand all the implications of family life. You should be very proud of that. I'm proud of you for that. But my position is a little different. You're going on the biggest court of this land with a problem out there that all women see one way or another in their life. And not all, but certainly married women do, and others too. And so the question comes, what happens? And will this justice support a law that has substantial precedent now? Would you commit yourself on whether you would or would not?
Senator, what I will commit is that I will obey all the rules of stare decisis, that if a question comes up before me about whether Casey or any other case should be overruled, that I will follow the law of stare decisis, applying it as the court has articulated it, applying all the factors, reliance, workability, being undermined by later facts and law, just all the standard factors. And I promise to do that for any issue that comes up, abortion or anything else. I'll follow the law.
Well, I think that's expected, and, well, I guess I've gone as far as I can. Let me go to another issue.
This hearing is not normal. It is a sham. It is a rush to put in a justice. The last time that we had a vacancy so close to an election was when Abraham Lincoln was president. And he made the wise decision to wait until after the election. The last time we lost a justice so close to an election. That's what he did. Today, we are 21 days from the election. People are voting. Millions of people have already cast their ballots. And I go to the words of Senator McConnell. The last time we had a situation in election year, he said, the American people should have a voice in the selection of their next Supreme Court justice. Therefore, this vacancy should not be filled until we have a new president. That set the precedent that so many of you have embraced, or at least you did a few years ago, and that is that in an election year, the people choose the president, and then the president nominates the justice. So why is this happening? Well, that's a good question. This guy, our president, he is the one that decided to plop a Supreme Court nomination in the middle of an election when people's health care is on the line with a case before the court on November 10th. So let's see what he said about the Supreme Court. Well, one of President Trump's campaign promises in 2015 was that his judicial appointments will do the right thing on Obamacare. You can see it right here. And in fact, Judge, just one day after you were nominated, this is like a few weeks ago, he said also on Twitter that it would be a big win if the Supreme Court strikes down the health law. So, Judge, my first question, do you think we should take the president at his word when he says his nominee will do the right thing and overturn the Affordable Care Act?
Senator Klobuchar, I can't really speak to what the president has said on Twitter. He hasn't said any of that to me. And what I can tell you, as I have told your colleagues earlier today, is that no one has elicited from me any commitment in a case or even brought up a commitment in the case. I am 100% committed to judicial independence from political pressure. So whatever people's, party platforms may be or campaign promises may be, the reason why judges have life tenure is to insulate them from those pressures. So I take my oath seriously to follow the law. And, I have not pre-committed, nor would I pre-commit to decide a case any particular way.
Okay. And I think this life tenure, this idea that you have, just for everyone out there, a job for life, makes this even more important for us to consider where you might be. And I know you have not said how you would rule on this case that's coming up right after the election, where the president had said it would be a big win if the Supreme Court strikes down the law. But you have directly criticized Justice Roberts in an article in my own state in one of the Minnesota Law School journals. It was in 2017. It was the same year you became a judge. And when Roberts writes the opinion to uphold the Affordable Care Act, you said he, quote, pushed the Affordable Care Act beyond its plausible meaning to save the statute. Is that correct?
Senator Klobuchar, I just want to clarify, is this the constitutional commentary publication that you and I discussed?
Yes, it is.
Okay.
It is, but it's still a University of Minnesota law. Yes.
Okay, I just wanted to be sure because I hadn't published in the Minnesota Law Review.
Again, did you ask that question? Did you say that he pushed the Affordable Care Act beyond its plausible meaning to save the statute?
One thing I want to clarify is you said that I criticized, Chief Justice Roberts, and don't attack people, just ideas. So that
Okay.
was just designed to make a comment about his reasoning in that case, which as I've said before, is consistent with the way the majority opinion characterized it as the less plausible reading of the statute.
Okay, so you didn't agree with his reasoning in the case that upheld the Affordable Care Act?
What I said, and was this King versus Burwell or NFIB versus Sebelius?
That was NFIB versus Sebelius.
Sebelius.
I'll get to King versus Burwell in a second.
Okay. What I said with respect to NFIB versus Sebelius is that the interpretation that the majority adopted, construing the mandate to be a tax rather than a penalty, was not the most natural reading of the statute.
But it was still the reading that Justice Roberts got to. Now, you also criticized, as you pointed out by bringing up King v. Burwell, another case where the court ruled in favor of the health law. This was in a 2015 National Public Radio interview. And you acknowledged that the result of people being able to keep their subsidies under the Affordable Care Act would help millions of Americans. Yet you praised the dissent by Justice Scalia, saying the dissent had, quote, the better of the legal argument. Is that correct?
I did say that, yes.
Okay, so then would you have ruled the same way and voted with Justice Scalia?
Well, Senator Klobuchar, one of the plus sides or the upsides of being an academic is that you can speak for yourself, that a professor professes and can opine, but it's very different than the judicial decision-making process. So it's difficult for me to say how I would have decided that case if I had to go through the whole process of judicial decision-making that I was describing this morning. Now, having been a judge for 3 years, I can say I appreciate greatly the distinctions between academic writing or academic speaking and judicial decision-making, such that a judge might look at an academic and say, easy for you to say, because you're not on a multi-member court, you're not constrained by stare decisis, you don't have real parties in front of you, consulting with litigants, consulting with your clerks.
Yes.
It's just a different process.
I viewed this one so interestingly because you were commenting on the public policy result, which you and my colleagues on the Republican side have said this shouldn't be about public policy, and you said, okay, that's okay, but then you were really clear on your legal outcome in terms of your view of whose side you were on. You were on Scalia's side, and of course that was a side to not uphold the Affordable Care Act, which would have been kicked millions of people off their health care in effect because they would have lost their subsidies. And I just see this as interesting because of this kind of dichotomy they're trying to make between policy and legal. And my view is that legal decisions affect policy. I mean, I'm looking at people in my state that'll deal with this if the Affordable Care Act is struck down. Elijah from St. Paul, who was born with cerebral palsy. Because of the Affordable Care Act, he is now 16 and is a proud Boy Scout. Casey, whose brother lives in Alexandria, and he has chronic kidney failure, and he needs a transplant. Without the ACA, that'd be that. Or Burnett from the suburbs of St. Paul, whose daughter has multiple sclerosis, depends on benefits under the ACA. Liliana of Fridley, who has a 21-year-old son with autism and needs her children to be able to stay on her insurance until she's 26. Melanie, a senior from Duluth, who's being treated for ovarian cancer and needs access to the Affordable Care Act. So my point is that these are real-world situations. And so I get that you're not saying how you'd rule on these cases. So what does that leave us with here to try to figure out what kind of judge you would be?
Something is not right around the court, and dark money has a lot to do with it. People who are watching this need to understand that this small hearing room and the little TV box that you're looking at are a little bit like the frame of a puppet theater. And if you only look at what's going on in the puppet theater, you're not going to understand the whole story. You're not going to understand the real dynamic of what is going on here. And you're certainly not going to understand forces outside of this room who are pulling strings and pushing sticks and causing the puppet theater to react. So first, let me say, why do I think outside forces are here pulling strings? Well, part of it is behavior. We have colleagues here who supported you, this nominee, before there was a nominee. That's a little unusual. We have the political ram job that we have already complained of, driving this process through at breakneck speed in the middle of a pandemic while the Senate is closed for safety reasons and while we're doing nothing about the COVID epidemic around us. We have some very awkward 180s from colleagues. Mr. Chairman, you figure in this. Our leader said back when it was Garland versus Gorsuch that of course, the American people should have a say in the court's direction. Of course, said Mitch McConnell. That's long gone. Senator Grassley said the American people shouldn't be denied a voice. That's long gone. Senator Cruz said, you don't do this in an election year. That's long gone. And our chairman made his famous hold the tape promise, if an opening comes in the last year of President Trump's term, we'll wait till the next election. That's gone too. So there is a lot of hard to explain hypocrisy and rush taking place right now. And my experience around politics is that when you find hypocrisy in the daylight, look for power in the shadows. What is the scheme here? Let me start with this one. In all cases, there's big anonymous money behind various lanes of activity. One lane of activity is through the conduit of the Federalist Society. It's managed by was managed by a guy named Leonard Leo, and it's taken over the selection of judicial nominees. How do we know that to be the case? Because Trump has said so over and over again. His White House counsel said so. So we have an anonymously funded group controlling judicial selection run by this guy, Leonard Leo. Then in another lane, we have, again, anonymous funders running through something called the Judicial Crisis Network, which is run by Carrie Severino, and it's doing PR and campaign ads for Republican judicial nominees. It got single $17 million donation in the Garland-Gorsuch contest. It got another single $17 million donation to support Kavanaugh. Somebody, perhaps the same person, spent $35 million to influence the makeup of the United States Supreme Court. Tell me that's good. And then over here, you have a whole array of legal groups, also funded by dark money, which have a different role. They bring cases to the court. They don't wind their way to the court, Your Honor. They get shoved to the court by these legal groups, many of which ask to lose below so they can get quickly to the court to get their business done there. The Center for Media and Democracy saw it, and they did better work. They went on to say which foundations funded the brief writers in that CFPB case. Here's the Bradley Foundation for $5.6 million to those groups. Here's Donors Trust, $23 million to those brief writing groups. The grand total across all the donor groups was $68 million to the groups that were filing amicus briefs, pretending that they were different groups. And it's not just in the Consumer Financial Protection Board case. You might say, well, that was just a one-off. Here's Janus, the anti-labor case that had a long trail through the court, through Friedrichs and through Knox and through other decisions. And SourceWatch and ProPublica did some work about this. Here's Donors Trust and Donors Capital Fund, and here's the Bradley Foundation, and they totaled giving $45 million to the 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 groups that filed amicus briefs pretending to be different groups, and both of the lawyer groups in the case. funded by Donors Trust, funded by Bradley Foundation in Janus. This is happening over and over and over again, and it goes beyond just the briefs. It goes beyond just the amicus presentations. The Federalist Society, remember this group that is acting as the conduit and that Donald Trump has said is doing his judicial selection? They're getting money from the same foundations. From Donors Trust, $16.7 million. From the Bradley Foundation, $1.37 million. From the same group of foundations total, $33 million. So you can start to look at these and you can start to tie them together. The legal groups, all the same funders over and over again, bringing the cases and providing this orchestrated chorus of amici. Then, the same group also funds the Federalist Society over here. The Washington Post wrote a big expose about this, and that made Leonard Leo a little hot, a little bit like a burned agent. So he had to jump out, and he went off to go and do anonymously funded voter suppression work. Guess who jumped in to take over the selection process in this case for Judge Barrett? Carrie Severino made the hop. So once again, ties right in together.
Do you agree with this particular point of Justice Scalia's view that the U.S. Constitution does not afford gay people the fundamental right to marry?
Senator Feinstein, as I said to Senator Graham at the outset, if I were confirmed, you would be getting Justice Barrett, not Justice Scalia. So I don't think that anybody should assume that just because Justice Scalia decided a decision a certain way, that I would too. But I'm not going to express a view on whether I agree or disagree with Justice Scalia for the same reasons that I've been giving. You know, Justice Ginsburg, with her characteristic pithiness, used this to describe how a nominee should comport herself at a hearing. No hints, no previews, no forecasts. That had been the practice of nominees before her, but everybody calls it the Ginsburg rule because she stated it so concisely, and it's been the practice of every nominee since. So I can't, and I'm sorry to not be able to embrace or disavow Justice Scalia's position, but I really can't do that on any point of law.
Well, that's really too bad because it's rather a fundamental point for large numbers of people, I think, in this country. I understand you don't want to answer these questions directly, but you identify yourself with the justice that you, like him, would be a consistent vote to roll back hard-fought freedoms and protections for the LGBT community. And what I was hoping you would say is that this would be a point of difference where those freedoms would be respected. And you haven't said that.
Senator, I have no agenda, and I do want to be clear that I have never discriminated on the basis of sexual preference and would not ever discriminate on the basis of sexual preference. You know, like racism, I think discrimination is abhorrent. On the questions of law, however, because I'm a sitting judge and because you can't answer questions without going through the judicial process, can't give answers to those very specific questions.
Okay. Thank you very much. Thanks, Mr. Chairman.
Thank you, Senator Feinstein.